Rajesh sir, please begin.
Bika, please start.
Yes, sir. A very good afternoon to everyone. I welcome you all to this webinar on Art of Advocacy and Career in Law. I humbly request Dr. Rajesh Singh, Associate Professor at Parul Institute of Law, Parul University, to further commence and begin the session.
So a very good afternoon to all the viewers. Myself, Dr. Rajesh Singh, Associate Professor, Parul Institute of Law, Parul University, Vadodara, Gujarat. First of all, I warm welcome Honorable Justice Satish Chandra sir, who is a very renowned former judge, renowned judge from the Allahabad High Court. He delivered lots of judgment. So first of all, I will introduce about, and the topic of this webinar is on Art of Advocacy and the Career in the Law. This session was arranged for the new students and what is the aspect of the career in the law aspect. So I'm just introducing about Honorable Justice Satish Chandra sir. So about Dr. Satish Chandra sir, he is enrolled as an advocate in the Bar Council of UP on 13/9/1975. He was LLM gold medalist and he has also done LLD. It is not an easy case to do an LLD. And Chancellor, and he's the LLD Chancellor medalist in the law. Furthermore, he is the specialization in the constitutional law, international law, and taxation law. After completing his education, he started practicing as an advocate in Allahabad High Court. Later, he served as a law teacher in Bareilly College, Dungur, in the PG College, Bikaner, and MD University, Rohtak, HP University, Shimla also. He was also a visiting professor in LBS National Academy, Mussoorie, Internal Security Academy, Abu, and various institutes in Russia and Poland. The Hague Academy of International Law, the Hague, he has awarded in the fellowship to Dr. Chandra. He was a visiting professor in the Institute of State and the Law, Moscow. He was a constitutional advisor to the government of Zanzibar as well as the judge of the High Court, Zanzibar. He was a consultant honorary to the Constitutional Review Commission of Zambia too. He was also appointed as the Sultanate of Oman as the first legal advisor. He also served as the Law Commission of India as Director Additional Law Officer since 1989 to 1997. He was also a judicial member in the Income Tax Appellate Tribunal for more than a decade since 1997 to 2008. He is an author of 15 books and 35 research paper articles on various aspects of the law. Elevated as an additional judge on 6/8/2008. Take oath as a permanent judge on 19/4/2010. So not taking more time, it was a very fantastic career ahead with Dr. Satish Chandra, and I personally visited in my Delhi trip. He was really a very fantastic man, and he is very down to earth, and I am really appreciate that he has written lots of books, and particularly he has gifted me one book of international law when I visited in the trip of Delhi. So on this note, I request, sir, we have Dr. M.N. Patel, sir, who is the provost of this Parul University, and he has having a academics of 35 years, sir. He was the Vice Chancellor of the Gujarat University, which is a very big university in the Gujarat. And right now, since last 5 years, he is the provost at Parul University. He always keen to listen to the Law Institute, and he always helped our Institute of Law at any point of time, whenever we required, sir. So on this note, I just request Dr. M.N. Patel, who is the Pro Vice Chancellor of this Parul University, to give a warm welcome. What do you, M.N. Patel, sir?
Ji, namaskar and good afternoon to one and all. On the program of webinar arranged by the Institute of Law, we are lucky enough that we have got a very good learned Satish Chandra as a judge of the Allahabad High Court. And as you said that he wrote so many books, and we are lucky enough that when the advocate or the judges are coming to our institute, joining by webinar, and whatever inputs they are giving to our students are really lucky enough for that. Especially our Institute of Law, where this Rajan Singh is arranging so many such lectures and talks. So our students are much beneficiary of it. As we see that the time has changed, now we are from the offline teaching to online teaching. and sometime in a hybrid mode. And it became, due to this, it became accelerated due to this corona. Everybody has accepted. The great advantage of this type of thing, a person who is very busy can spare few hours or a few minutes for us and to talk with the students. Really, it is inspiring. Otherwise, to come physically and to waste the entire day or so, it is almost impossible. So indirectly, this hybrid teaching or so-called online teaching, virtual teaching, it became very, very effective. As so far, the students, they are getting a very good exposure of various learned person, those who are the expert in their field. And at Parul Institute of Law, we have seen that more than 100 research program during last 1 year. We have a plan calling such learned person, and our students are the beneficiary. I hope so that today he is also going to talk on the topic which is said that that is the art of an advocacy, and that is the career in law, how it can be make our career better. I think the tips or whatever case studies will be discussed by our speaker of today will definitely be very much useful to our students. So with this, again, I welcome Sri Satish Chandra ji to Parul University, and hope so that in future, if you have time and you can come physically, we will welcome you again whenever you will join. But today, I hope that whatever deliberation will take place, our student will definitely be the beneficiary of that. With this word, I congratulate the entire team of law for arranging nice and so many type of programs which include every topics, so that the teaching learning became much faster for our students. So I welcome again all of you. Thank you. Over to you, Rajesh Singh.
You are on mute.
I think Principal Madam has joined, na?
Rajesh, you are on mute.
Now I request Dr. Namita Vyas Joshi ma'am to say the few words about this event, and then we will start our event. Over to you, ma'am.
Thank you, Rajesh sir. Thank you very much. Sir, first of all, I would like to introduce myself to Dr. Chandra sir, Justice Satish Chandra sir. First of all, that myself is Dr. Namita Vyas Joshi, as I think Rajesh Singh sir has introduced me. A very hot welcome to you, sir, on this occasion, and it is really an honor to have such a wonderful person like you and a knowledgeable personality like you. And the most important thing that you are just speaking about the art of advocacy and the career in the law. That is the really, I think that it's really very meaningful for the law students, sir, actually. And I would not do them much more time. And thank you, Dr. Emil Patel, sir. You always inspire to all of us, and whenever you appreciate us, then we get motivated, sir. So thank you very much, sir. And please welcome Dr. Satish Chandra, sir. Please welcome. Welcome. Good to you, Rajesh, sir.
Thank you, ma'am. Dr. Namita Vyas Joshi ma'am. Now we will handing this session to our former judge, Dr. Satish Chandra sir, for giving his wide experience on this topic on art of advocacy and the career in the law. So now I am handing the session to you, sir. Over to you, sir.
Good afternoon to everybody. First of all, I will express my thanks to Mr. Patel, Dr. Patel, for speaking nice words. And in fact, the last year when I was delivered some lecture in Parul University on EMOD on the order of Mr. Rajesh Singh, then he was not present, but today I got a chance to see him also on this one. And Dr. Rajesh Singh had persuaded me to deliver this lecture for the students. So this lecture is for students. So now for students. So I will say first of all to my students, congratulations for joining the law. And the law by choice. During our period, the law was the last choice. But now this is a choice, first choice to choose it. Earlier, if somebody is not getting job or proper admission in science or medical, he joined the law just to pass time. Like a girl who is learning knitting, embroidery, etc. till getting good husband. So till he was not getting a good job, so he joined the law, and by accident they he did law. But nowadays, 5 years integrated course has given the opportunity to the students in the beginning to choose the law and to choose this one. And in this context, I can say the Parul University has made a remarkable place in the field of the law. I am associated with the Bar Council of India, Legal Education Department. I have seen the Parul University's output, students and some former students, and I found very nice persons them and genius. They have got a proper knowledge, and that is why I can say the Parul University has created a dent in the field of the law. Now coming to the topic for today's topic, first of all, I will say this is a very tough profession. As Rajesh might have told in the classroom, this is not a business, this is not a trading where goods are sold and purchased. This is a profession like other professions. But this is a very tough profession. And here is a phrase in the law: the advocate will always suffer the hunger. If his advocacy is running, doing very well, he has no time. If he is not running, then he will die hunger. So in both the cases, he will suffer the hunger of this one. And in this profession, those who are coming, they must have the patience, at least for 5 or 6 years. In this profession, in the beginning, don't expect anything except the hard work. You will have to do hard work in the beginning for the client, for learning the aptitudes, even the court clerk's manners and the clerk in the advocate's chamber. So don't expect that you will run or you will earn the money. So if those who have no patience, they need not to come. My advice is this: those who have the patience or the ancestral profession, they may come in this one. They will get immediately the client, they will get immediately the office. Otherwise, one generation will go for creating the office and for creating the clients. That is there. And don't expect in this 5 or 6 years that money will come. Money in this profession is like shadow of your own shadow. If you will run after the shadow is far away from you. If you will leave it, shadow is behind, the money will follow you. And that will come, and money will come after 5 or 6 years. So this is there. If you have patience, then join it. If you will see the big advocates, always, or those who have made the names, see their finance, how much tapasya they have did, and what hard work they did. So only after some times they got it. Justice Polly and others, they got the clientage after the 6 years or 7 years, and later on they became the judges, and they did very well. So in this, my first advice is to the student is have the patience and then join this profession. If you have no patience, then it is not perhaps the good profession for you. And when you appear in the court after this one, first of all, remember one thing: you are the friend of the court officer. You owe some responsibility. So never lie in the court, or don't misguide, or don't give the false information in the court, because you are the officer of the court. MS Curie, when the court appoint you or ask some questions from you honestly, so they means you are the friend of the court. So on these aspects, you must keep your status in your mind, what is there. And when you are appearing in a case, particular case as an advocate, remember that you are the receiver and you are before the my lord. My lord means God, like God. So you are asking from the God. So never argue, never have this one. And because you are the receiver, like a beggar, and you ask and do the prayer and put your case, and then maybe made for this one. For this one must be very polite before the court. Never offensive. And nowadays we have seen some contempts are going on. Some advocates have thrown the chappal. They have did very bad things. So that carries the bad name, and ultimately matter goes to the Bar Council Disciplinary Committee for the cancellations, suspension of the bar license. So remember one thing, that you must be very polite in this one. I remember one case in section 68 of the Income Tax Act. Those who are teaching and those who are aware of this one, there is a provision for the cash credit in the book of accounts. they laid down the cash credit, how much payment has come by check, or all these things. But title is the cash credit. Payment may come through any source. So when the matter reached to a judge who was totally unaware about the tax matter, totally unaware, he asked, Mr. In this case, there are so many checks. How it has become the cash credit? This is a check credit. So advocate understood that a judge is not aware, or he never says you are a fool, you don't know basic things. He was very polite. He submit, lordship is correct. But right, sir. But these checks were encashed later on, so it becomes the cash credit. So he twisted the things, but he never said to judges that you are totally unaware or you are totally distant. So be polite and twist the things according to your choice, what you want, and can do this in politeness. And when you are arguing a case, particular case, you must take the court with yourself. Take the court with yourself, and so that what you are teaching, what you are speaking, what you are doing, court must listen it. And if you feel at any time that court is not listening, or indifferent with your arguments, then stop. Have a pause. For example, there was a judge who was going to the courtroom with his pet dog, and single judge he was sitting. So when the advocate was arguing, perhaps arguments were not interested. He was not interested in arguments or something like that. So he was rubbing his dog on the left side. So the advocate noticed that judge is indifferent. So immediately he stopped the argument. Just said, no, you continue, please. Okay, my lord, I can continue, but I was thinking that you are in consultation with this one. So not this one. So he immediately paused, and then judge realized and leave that one dog and listen the arguments. This thing. So such type of this things situation may arise. And I said to this one, he took the court with you always. And if court say likes Shri Krishna, say Krishna. If court likes Salam Alaikum, say Salam Alaikum. Likes Namaste, Namaste, like this. जो तुमको है पसंद वही बात करेंगे. To starting this one. So took that one and starting that aspects for practice. During the arguments, there must be the arguments for confining to the facts of the case. No personal argument, no personal enmity, or nothing should be mentioned, or arrogancy is not required in this profession like this. And if you think that court is not with you, then change the line immediately. I was listening a case about the sale tax, and issue was the ice cubes is taxable sale tax or not. At that time, there was a sale tax, then VAT time, and now goods has come, GST has come. So old case was there. So question was this: the ice cubes which we are using in the drink, other things are taxable or not. So the argument was started by the advocate. My lord, water has three shapes, three positions. One is ice, another is water, and third is steam. Water is not taxable. How this can become taxable? Ice cubes can become taxable. So this was his argument. So I asked a question. Sir, if you will ask the ice cream is taxable, sale tax, but sweet milk is not taxable. You will freeze. The same analogy is there. So that is there. Secondly, if you need the ice cubes, can I give you the cold water? Will it solve the purpose? So both are parlance. In parlance, both are different commodity. So immediately he understood the bench is not with him, or judge is not with him. So the advocate said, sir, very intelligent question. Very intelligent question. I never thought this line. Kindly give me some time to prepare the case. And he sought the adjournment. And during my regime of 8 years, that case never came before me again. So this was the art to save these things, because he understood that the judge is not with sorry. So always took the judge with yourself, and when you found that you are losing or you are not with him, then seek the adjournment and go to other aspects for this one. In the courtroom, another things are, because this legal profession is an art. So in courtroom, you must also learn the presence of mind. There must be this one. One advocate was arguing. So just said, we understood. Am I fool? Just said, am I fool? So the advocate politely said, sir, if I will say the truth, that will be the contempt of court. If I will not say the truth, it will amount to perjury, false things. So naturally, the atmosphere was converted into laughter, and then things were settled down like this. So presence of mind always shows the problems and make the atmosphere in the courtroom congenial atmosphere, lighter atmosphere. Never give the burden, never these things. And when you are doing the practice, you must be dedicated to the client. Dedicated to the client means nowadays in Delhi, I have seen there are so many courts, district courts, tribunals, so many, and advocate is running from one court to another court. Client is searching, where is my advocate? Where is my advocate? So that is a very bad impression. And he told some junior or some his friend, kindly seek the date. I am going to such and such court. I am going to another tribunal. That is not the good practice. I remember when I was a litigant, in CAT, there was my advocate, and when I lose the case, I asked him to appear before the High Court because he was well aware, and I was fully satisfied by his performance. He said, "Sorry, sir, I cannot leave the premises of the CAT. I cannot go to a High Court or to another place. Whatever fees you will give, I will not give." And that I like. So my submission is for the advocate is whatever court you will have, please hold it. In Ambika, I went there, and General Secretary asked me to come in the evening and bar and all these things. And they asked me to deliver a lecture about the pendency in the courts in India. So I told them there is one reason for the advocate strike. And they laughed. What is the strike by the advocates? They laugh, and later on I realized and I asked my host, what is the reason? And then I went deep and deep and deep and deep. Then I found that thereafter obtaining the license of the advocacy, the person is entitled to practice in 2 or 3 places, 2 or 3 courts. And the head of the court, like the Chief Justice or the district judge, whosoever is there, he will give the license for 2 or 3 years. So an advocate has license for 2 or 3 courts for 2 or 3 years. So he can't do strike because his license cannot be renewed later on. And he is confined within 2 or 3 courts. Now, learner in India, the learner advocates needs the money, he needs the clientage. If he gets the chance to appear in the tribunal, he will catch it. If he will get a chance to appear in the criminal court, he will catch the district court's matter, even high court matter. So he will try to grab more and more cases. So my advice is this: please confine to your this one court. Choose your court where you want to do practice, or if not so, then make the associates. Make the associates, or this associates will always in the evening they can meet and they can distribute the case. You look the Patiala House case, you look the tribunal's case, you look this one, but the person must be the specialized in that court. Somebody is looking for the tribunal, he must have the tribunal's cases. Whatever source is there, either from the associates it has come or directly from the client it has come, or like this, and he will become the specialist in that court, particularly court, and people will like him and dedicate it to the client, and he is always available to the client, and client is satisfied that my advocate is present, whether matter will come or not. Last week I was doing some arbitration, so one advocate, Shashi Bhushan Upadhyay, SP Upadhyay, senior advocate, he asked, "Sir, give me 1 hour. I will have to go there. My case is there." Okay, your case at what number? 156. Okay, it will never come. That I know it will never come, but my client is waiting for me. So I will have to be there. I know that will not come. So the presence of the advocate in the case is the full satisfaction to the client that his advocate is present and he is doing all these things. In this profession, the honesty towards the profession is must. Another aspect of this one, honesty to the profession. I'm giving one example. When I was in Lucknow, they gave me the single service matters, old single service matters, meaning thereby 91, 92 years. The case was decided and this was admitted. In some cases, stay was granted. In some cases, no stay was granted. So all rubbish cases were came. By flash of time, cases have become the infectious. 99.9% become the infectious. So even advocate says we have no instruction from the client. Means we have no money, we have no fee, we have no instruction. But I found 3 persons, very aged persons. They came. They said very simple. Look, sir, my lord, we don't know where is our client. We are not concerned with the fees, but my wakalatnama is in the case. So I will have to argue this case. And when I will have to argue, you will have to listen and pass the order, appropriate whatever you like. So I became admirer of those advocates, 2 or 3 advocates out of 11,000 advocates, that they were dedicated towards the profession. There was the honesty of the profession. They were present, even client was not there because their wakalatnama was there. In modern generation, they will say we have no instruction from the client, meaning thereby we have no fee. Nothing is there. So dismiss it in default or whatever may be, that is there. So this aspect should be. Another, when you are appearing to the court, because it's how you will prepare the case. Your teacher might have told you the drafting, pleadings, ethics, all these things they might have told you. But I'm telling the practical aspects. When the client comes, the file, Munshi gives the file, Munshi means the clerk gives you the file. You keep the fees in your pocket, later on shift it to your wife, spouse. That fees will immediately go to the wife, and file will go to the clerk, and clerk will put into the cold storage after this argument or initial hearing. And then he understood that case will come after 10 years like this. So this is the practical thing. After 10 years, they will search where is the client. They want the brief like this. This is the practical position in maximum cases. But I found, with due respect, Shanti Bhushan, advocate in Supreme Court, and other advocates I met, Hari Salve, what they did when the case file came from them, they considered that this is tomorrow is the final date for the hearing. They consider it. So what they did, they asked the client, have the brief, put the questions, and make the notes. And notes in their own handwriting, not a dictation. In own handwriting, they prepare the notes and they keep these notes into the file. And then forget, whenever case will come, they will take out the file, notes are there, they can read it, they can develop it, and they can go through at a glance, and they can argue it. At that time, there is no need that there will be a conference or meet the client or fees, etc., etc. That was not there. So they prepared the case for this one. After this one, as I earlier said, there must be you must present in a particular court always, and by that you will acquire the specialization. If you are dealing in the income tax appellate tribunal, so you will become the expert in taxation. If you are in criminal law, you will become the criminal law. Civil law, civil law. So by subject matters, even matrimonial, even bounds of the I met one advocate in Aligarh. He is dealing exclusively on 138 Negotiable Instrument Act. That's all. This is specialization. And he said no brain is need to apply because routine language is there. So he prepare and give this one. And all the checks cases are coming to him. He becomes the expert in that one. In Delhi also, RTI expert. To go, they will prepare the question, what to tell them, and they charge their fee and they will put the RTI on your behalf. So such type of specialization is there. So for this purpose, my suggestion is there, we make a group of the advocates, your colleagues or associates, and put the name of associates in the evening, meet them, and whosoever has the if cases of the matrimonial, give to the advocate who is dealing exclusively in matrimonial in a particular court. If the matter is the taxation, give them. GST, GST, the service tax, service tax. So many taxes are there and so many matters are there. Even ED cases can be given to the person who is dealing exclusively for the enforcement directed cases. but you cannot become the master of all judge. Don't try to become the master of all judge. To know the basic law, judge can be the judge, can be put in any jurisdiction. He may be the master of all judge, but not the specialist. So try to become the specialist. So on tips, whenever the case will come, then you can talk. For example, if tax matter comes to before me, I can say international taxation. Okay, arm's length price. What is that arm's length price? I need not to go through because I know what is that arm's length price. Multinational companies, what they are doing. So that is there. So acquire the specialization. And when you are going to the court, how to start the arguments? How to start the arguments? By wishing the court, you should argue the case and give the brief introduction of the case. Briefly, very briefly, because judge is totally a known person. He might have not gone through the file. He is opening the file first time. He don't know what is in the file, but you know very well what is in the file. So what is the crux of the problem? Tell them. I ask usually, what is the crux of the problem? What is the net things in this one? So by that, judge may develop a mind in mind to what is the position, whether this is cognizable or what can be done in this one. So give the brief introduction of your problem and crux of the case. Then you start your argument and expect what opposite party will put the objection to your argument. We have gone through the cases in details. You may expect what will be the potential arguments and note it down and make the brief notes and then start this one practice and you can solve and you can be a friend of the court and can be helpful. And where position is against you, you can tell if this case is against me, but I am distinguishing. Distinguish that case on the facts. People came to this one that this ruling is against me, but I am distinguishing it on the facts because this were the facts quite different. And there is a basic principle that ruling will have to be read with the facts of the case. A particular ruling is applicable, which was given in the particular facts of the case. So this is there, how you can start the argument, expect the question from the opposition, brief is there, and as I told, judge is totally unknown. He might have not opened in the file before. And first time he is opening the file because there are so many cases, it is not possible to do this one. In Allahabad High Court, I was having the list of 220 cases, listing 220 cases. And in the beginning, the fresh matter came, 40, 50. And then mentioned cases came. So where is the time to go through? And more than 3 crore, 3.3 crore pendencies in India. So how you can expect that judge might have gone through the file like you because you have 1 or 2 lines. So that is there. And be submissive, as I said earlier. If judge is saying no merit, throwing it, so we have no, sir, admit it. So we have no space. We have no space. And no, this is dismissed, this will go. Then a advocate will say, my lord, in my chamber, 1,000 files are there. In your chamber, lakhs of files are there. But for this poor client, this is the only file throughout his life. This is the only file. So such type of things can be used sometime and can be started this one. Another aspect in this one, let me. After the courtroom, your duty, what is with the clients? Because you are working on behalf of the client. So clients, behavior of the client must be good. Sometimes I saw few advocates, especially senior advocates, they are misbehaving the client, you don't know, like this, and they are speaking for money only. Every time they are seeking the adjournment, and in court, old days, there was a letter, standard letter, printed letter. If the case came today for hearing, maybe on the last hour, so and so judge has argued too much, and but opposing party was unable to reply it, so case was adjourned. Now you send the fees to so and so. This was the standard format. Nowadays, the clerk they send the message, standard message, same message, Please kindly transfer the fee in such and such a. Only this purpose is there, but my not like that. I'm of the view that behavior towards the client, ultimately he has given the bread and butter, must be good, and his case should be try to finish his case honestly as early as possible. I remember there was a Nawab Saab who was an advocate. Son was also an advocate. So senior advocate had gone out of station. Junior advocate came. He was working. When a senior returned, he told, "Father, I have finished the case of Rai Bahadur, which was lingering on from last 20 years." And he was expecting some appreciation. But father has slapped him, beaten him, and told, "Bloody fool, that was the case by which your education was completed, your sister's marriage was completed, and you have finished it. So don't, that was the old days. But nowadays, more turnover, more profit. A client is not satisfied, you are squeezing him from last 20 years, 10 years, and every time you are asking money. So ultimately, he becomes frustrated. He will never ask friend or anybody else to refer the same advocate for their cases, new cases. This profession, mouth to mouth publicity is good. If your client is satisfied, he will send you 2 more clients. If you will squeeze him, if you will expect from him, he will never send or refer any case, but his neck is in your hand, so you can twist as much as you like. So my submission for the new generation or the students is this: try to finish the case honestly as early as possible. Then you will get the new cases, and the same person will came again in another case or will bring 2 or more cases if you listen there. So behavior with the client, satisfaction of the client. About the fees, nowadays on every hearing, on every date, for every cause, either clerk will speak or the advocate will speak. And that is why this profession is not an honest profession or it's a defamed profession. In this context, I appreciate the Western Singapore's concept. They fix the fee in advance. This will be the total fee. And I remember my friend was there. He said there was a need to file an affidavit for interim direction. Some affidavit was required to file. In the evening, the advocate's person came, brought the affidavit, obtained the signature, and went away without taking any money. And it was filed. In India, if affidavit is there, clerk will ask the money, advocate will ask the money, and they will speak the client time to time. So that is not a good thing. If you will adopt the new generation, fix the fee, it is the total fee, including your expenses. Including your expenses, and you pay according to your choice in phase manner or lump sum, whatever you like. Nowadays, corporate are obtaining discount. All international companies, those who are dealing multinational business, acquisition, valuation, publicity, all they are doing these things. They have the fixed fee, no squeezing, and for money, as again I will say, this is like a shadow. Don't behind. Shadow must be behind, not away. Don't follow the shadow. Shadow will follow you. So these are some aspects in the practical one. And lastly, I will say that no substitute of hard work. Work hard, as I said, you will be hunger, you will die with hunger if your practice will run. If practice will not run, even then you will die. So no substitute of hard work, and it will never go waste anywhere or in another form. So this was the first aspect of the art of advocacy. If somebody has a question, he can ask. Dr. Rajesh, is there any
Yes,
provision?
sir. It was a very fantastic session by you, sir. You have elaborated the things in a very elaborative way. You have made the entire content in a very systematic way so that my student have understood in a more better way. Sir, we have certain question to you, sir.
Please, let me finish the second part.
Yes, sir.
Question or first part question?
Yes, sir.
Second part of your topic today is the
Yeah,
career
sir.
in law.
Career in the law. Yes, sir.
Mr. Rajesh, Dr. Rajesh Singh might have told you there are so many ways, so many professions. Main profession is the advocacy. In Delhi University, K.B. Rotaki is no more. He was saying the first two benches, students on first two benches will become the academicians. Middle benches will become the bureaucrats. And last three benches either become the politician or the advocate.
Yes.
That was there. So in this one, I will say the advocacy is the profession where 90% people are consumed or absorbed in this one. Legal advisor without doing practice in international companies, in every company, in every department, in public sector undertakings. A legal advisor or legal section is required. I wrote the third pay commission of the central PSUs, 293 PSUs. I found that every PSU has a legal department, their expense is much higher in litigation or for another reasons. In some oil companies, the litigation cost was in crores, which can be reduced easily. But that system is going on, so going on, what you can do. So this legal advisor in every company is required, department is required, PSUs is required, and as I said, the academicians, you can become the academician teacher like Dr. Rajesh Singh and Dr. Mohammad Salim Khan, Nirmala Ayas Joshi. So like they can become the academicians, wrote their papers, eminent jurists they can become, and their advice sometimes can be used by the court. This is there. Another is ambitious is the judicial position. That is the lower judiciary by competition. Higher judiciary and high court judgeship is also there from the bar after the practice. So that is another venue for the law graduates, but it will take time and needs hard work. Legal writer, editor, journals. In every journal you will find the editor, and they are the law graduates, and they are doing the legal work in that one. Specialization, experts' opinion that is there in international, especially in international commercial organization like OPEC, oil producing export countries, Amnesty International, UNITAR, Human Rights Amnesty. All these are there are so many international organizations, so many NGOs where the legal advisors are required for legal section. It's compulsory, and you cannot avoid these outlaws as you cannot avoid the in-laws. As in-laws are the necessary, he will. So these are the necessary things for this one, specialization. And legal consultation is another this one. Without doing practice, they can do the chamber practice, and consultation may be there. And another this arbitration. Nowadays, it has been made compulsory that in every civil contract in this infrastructure, the arbitration clause must be there. Because court cannot decide your case. In Allahabad High Court, 10 lakhs cases are pending, 1 million, more than 1 million cases are pending. So how you can expect that your case will be listened immediately in writ petition or like this? Because it requires this long cases between the organizations and the contractor who has built the roads or who has built the sea or tunnels or like this. So it requires deep study. So this arbitration is there, and you will surprise L&T, Afcon, all these big industries. I'm giving their cases. They are having the legal department, much higher department than their technical department. And when the contract contract was awarded, oil producing countries or this ONGC, immediately the legal department become active for that project. So they appoint the legal department who are complete legal officers, legal department for that project. Because project will go for 5 years, 6 years, 10 years. So all they will start writing the letter. There is a delay on your part, like this small delay, because government department will take 5 days with approval or like this, but immediately they will shoot the letter, and in a professional manner they will do. NGOs, another avenue for this legal professions. And, by these things, I think there is a need of the law everywhere as we need in law. So this is the career in law. Briefly, I told you. Now, Rajesh, you can ask the question.
Yes, sir. Yes, sir. Thank you very much, sir. You have elaborated both the topics, art of advocacy and the career in the law, in a very systematic way, sir. Sir, we have certain question from the student. Sir, the student has asked that in the professional misconduct by the advocate for retaining the money from the client. Sir, what is the possibility? Already we have one judgment of Bar Council of Andhra Pradesh versus Kurupati Satyanarayan, AIR 2003, Supreme Court 178, page number, sir. Sir, what is your take on this particular thing, sir? What the court should give the judgment in this particular types of matters, sir? Over to you, sir.
This type of cases, one should be very determined person. Recently, I was reading for recovery of the 39 rupees on the refund from the railway, the person fought for 7 years or 8 years. Ultimately, he got it. So, who has the patience for this one in India? As I told you, the 3.3 crore cases are pending. Your case will be one of them after that. So, how it will be possible? However, if you suffered a loss, then naturally you have the remedy for the misconduct. And as the Supreme Court awarded the compensation in that case also, and Bar Council of India can also take the action. But problem is this: in Bar Council, I am there. It is dominated by the advocates. So brotherhood will come. So punishment hardly awarded, or maybe suspension, or like this. They said we have a soft corner. He is our brother. Like this. Ultimately, we will have to contest the election next year, and he will be our potential voter. Then Bar Council, very effective remedy is not available. This is only in the court. You will have to go, and you can do it. No problem. But have the patience. If one has the patience, only then this is there. And remember that advocate is in the advocate, and you are not. You are the client, and you are still client. So you will have to engage another court, another advocate. And brotherhood may be there or may not be there. So think for this one and then start pressing.
Very true, sir.
And
Sir,
wrong advice of the advocate is a,
yes,
good
sir.
ground. Is a good ground for condemnation or delay and to start the case.
Sir, one more question, sir. If the advocate takes the money from the client and he misappropriates that particular money and, and not doing the particular work, so what should be the remedy available?
Again, the question is this misconduct of the profession.
Yes, sir.
This is a misconduct of the profession, and the answer is the same what I told you.
Yes, sir. Yes, sir. Sir, we have different judgments of the misleading of the case, which we already you have taken in your lecture, sir. Sir, as per the dress code of the conduct of the advocates, sir, we know that everyone has to. And sir, we have one question that in the case of High Courts and the Supreme Court, the advocates were arguing about my lord or your lordship. Sir, what is your correct pronunciation should be given to the judges, sir? Can you just elaborate in 2 words, sir?
Dr. Rajesh, we are following the British system, Commonwealth system, and there were the my lord. My lord
yes,
means my God. And during my
yes,
lecture, I told you, you are seeking the favor, you are asking the begging, you are a beggar like a beggar, and you are asking from the God. The
yes,
relief
sir.
can be given to you. So my lord was there, but now that legacy has gone, and Supreme Court has taken interest, and they said my lord word should not be used, and you can use sir. No problem.
Okay.
That is
So
there.
that's true, sir. We are just confused in this. So that's why this question was asked by one of the students of LLM. Sir, secondly, sir, you have elaborated.
As
Yes, sir.
full form as slave I remain.
Yes, sir. Yes, sir. Yes, sir.
Slave I
So,
remain.
sir, yes, sir. So it was a very fantastic session, sir. We have 3 questions from the students, and you have elaborated the art of advocacy. There are various important things: dress code, behavior. You have also elaborated about the conduct of the court. The student has to maintain. The student has to learn how to prepare for the matter, how to make the good notes, and that is the about the advocacy. If you are not preparing your case in a better way, you cannot ask. And secondly, sir, you have also elaborated about the provisions you have to incorporate in the drafting, that the drafting should be very simple. The judge should understand the drafting in a more better way, That is the basic important aspect you have explained. And on this note, sir, we are very much thankful. Now I will tell our Provost Chancellor to say a few words, and then we will give a vote of thanks, and then we will close. Dr. M.N. Patel, sir.
It's really a pleasure to hear Justice Sir regarding that art of advocacy. I also learned little bit, and our student are definitely be much benefit of it. So really we are happy, and we are arranging this type of such webinars, calling a various expert, and that is a really a great type of learning for us. So naturally, Rajesh Singh is taking a lot of pain and contacting all such learned person and planning to have they are with our students. So our students are the most beneficiary as so far the experienced people are concerned. So I hope that this session is a very beautiful. Our students have learned a lot, and hope so that many such sessions may be there in the future. Thank you.
Now I will ask Miss Ambika Batas to give a vote of thanks, as she is the co-coordinator of this event. Miss Ambika Batas, please give a vote of thanks to sir.
Good evening, sir. Thank you so much for joining with us. I'm really grateful to you for giving us your time and giving us your valuable knowledge. I'm sure the students would have been greatly benefited by this knowledge that they have gained today. And with respect to Art of Advocacy, I'm sure it's going to be most useful for them right now to understand what they are going to do in future, how they are going to go about it. And you have very nicely elaborated how they can pursue their career in law and what all they can include in their career right now, in their syllabus right now, and how they can go about right now in order to have a beautiful and prosperous career further ahead. Thank you for your time, and thank you for sharing your knowledge with us. And I'm sure we are immensely glad to have you and host you today.
So thank you, Miss Ambika Batas, and sir, we are very much thankful to you. Now I will tell our Dean, Dr. Namita Vyas, to say a few words, and then we will close our session. Dr. Namita Vyas, ma'am. Ma'am, your voice is not audible, ma'am.
Good.
Yeah, ma'am. Now it is audible.
Dr. Satish Chandra sir, I'm quite young to say that, but the way you delivered your lecture, that was really very nice. And another thing is that the way you are speaking and explaining the thing to the student, that was really very clear. But like the one place, the each and everything was cleared, and it's very fruitful in actual, I must say. So, on behalf of the Parul Institute of Law, I'm very thankful to you, sir. And another thing is that even though just like the way you says that no, my one session is remaining, I want to further. So it's the fact that you are putting more and more efforts. And another thing is that, sir, even though I think that why don't it's on an offline mode, sir, whenever you are free, then I look forward, like, sir, whenever you are free, then I prefer once you come here and please address to my students on offline mode, sir, please. It's my humble request to you, sir. And again, thank you very much, sir.
Thank you, Dr. Namita Vyas Joshi, ma'am. And thank you, Dr. Satish Chandra sir, for giving the valuable time to our university. And we are also try that in the next time, sir. I will visit your again office. And secondly, that sir, you are always humbled with the Parul University. Whenever I have asked you, you always there with us, and you always emphasize that yes, Parul University is doing a very fantastic work in this academics. And on this note, I am thankful to you, and I am thankful to Dr. M.N. Patel, Pro Vice Chancellor of this Parul University, and Dean Dr. Namita Vyas, ma'am, and Professor Dr. Debati Halda, ma'am, for in this particular session. So on this note, we are closing this, and we are also thankful to Jiten Kobhani, who has given this particular things for giving the live session on this Facebook. So on this note, sir, we are closing this session. Thanks a lot, sir, for your kindness. Now we can leave, sir. Thanks a lot, sir. Yes, now everyone can leave.